It's Reality Check with Craig Price.
I'm an idiot.
4 minutes in and I'm already wrong.
I'm like a monkey. Hello, look at me. Craig, shut up.
Hey, I need you guys to do these things.
You're like a beautiful mind. I'm more like Forrest Gump.
So welcome to Reality Check with Craig Price. This week, Ben Neiburger joins me to talk estate planning. Thank you for listening. As always, you can find past episodes of Reality Check at realitycheckpodcast.com, or you can head over to iTunes. If you do go to iTunes, please leave a nice review and a 5-star rating. I'd certainly appreciate it. But the show, for new listeners, comes out every Tuesday at 7 a.m. Central and is available on until infinity. So head over, subscribe, and listen. We'd really appreciate it. Now that we get some of that business out of the way, let's talk about this week's guest. If you're anywhere near the ages of 30 to 50, you're probably dealing with elderly parents right now, or you're at least starting to think about what could happen. I mean, my dad is turning 70 at the beginning of next year, and I know while he's in pretty good shape now, he's getting into that age range where you start getting nervous. You start wondering, what if? I mean, America in general is aging, and baby boomers are retiring, and no one wants to talk about it, but getting your affairs in order is a responsibility any spouse or parent needs to start thinking about now and not when it's too late. Today's guest, Ben Neiburger, is a Chicago attorney that specializes in generational law, and estate planning is only one of the topics he's an expert on. And I know I learned a couple things about that my wife and I need to address, and we're still in our 30s, so it's never too soon. So let's jump right in and talk estate planning with Ben Neiburger. Getting your affairs in order is kind of a touchy subject because not every person, most people don't even want to think about it. And I think that's where most people fall into the trouble situation, is that they don't think, I'm going to die. They're not thinking I'm going to die soon, especially as they get older. They think about dying, but they don't go, oh, I'll be dead next week. What is the things that you need to start thinking about, and how early should you start thinking about getting your affairs in order?
Well, the tongue-in-cheek answer is before something happens to you.
Well, yes, I would certainly hope so.
Well, here's the real issue is every state has different laws, and each state has made a set of default rules if you haven't done anything. And nobody likes the default rules. So here's an example. Let's say that you have a bank account, and your name's on the bank account, and that's what you use to pay your mortgage, to get dinner, those kind of things. And then you get in a really bad car accident. And it's not a really bad car accident because you're not dead. You're just severely disabled and can no longer communicate. If you don't have some of your estate planning documents done, the default rule is pay an attorney and go to court, which for me is one of the best things in the world that I've ever heard. But no family is happy with that. Or many states have a default rule that when you die, the stuff that you have goes half to spouse and half to your 19-year-old who's in college partying.
Really? They bypass the spouse altogether?
Well, the default, at least in my state, in Illinois, half to spouse, half to kids.
Wow.
And so, of course, you don't want that.
Of course not. You
want it all to go to the cabana girl.
Well, I'd like it to go to my wife. I'm assuming your wife.
The thing is if you have a will, you can change the default rule, but the default rule goes half to kids, and that's not appropriate in many instances.
That sounds amazing to me because it almost seems like, standard issue would be, next of kin, which would be your spouse, in your case your wife, but apparently your wife is not going to listen to the podcast, so a cabana girl, and then it would go to if she happened to die with you or she wasn't alive, then it would go to the kids. Is there any reason why they do that? Was there some kind of law that something happened while they said, well, we've got to...
I mean, the real big problem is you're trying to apply a logical construct to something that the government made up. And the logic frequently doesn't apply. I really don't know why. In some situations it's appropriate. Say if there was a second marriage or something like that. Then maybe you split it up like that. But I really don't know that's why that is the default rule, and it might be different in different states. This is just how it works in Illinois. But each state has a share of rules that you don't like. And here's another one. In my state, if you go through the probate process, which is you go to court and have a lawyer do everything to pay the debts and to get everything to go where it's supposed to go, you have to post a surety bond, which is an insurance policy that makes it so that you don't steal from the estate.
And that's something that seems to be kind of not necessarily happens a lot, but it seems like the only real reason that you would need any kind of estate planning attorney like yourself is that, there's weasels in your family.
Sometimes, yeah. People and money, when they get together, fun things happen. And what the law says is when they made up the rule in the rare lucid moments where they were thinking logically, it's you better have an insurance policy in case somebody steals from the estate so you can make the estate whole. And then the bonding company goes after the bad person to try to get the money they just paid out.
And for my listeners, I'm here with Ben Neiburger with Generation Law. And you not only handle estate planning, but you talk about, elderly care and it's
basically helping adult children get through the caregiving process, either with the spouse or with their parents, which, sucks your life away.
Yeah, because I wanted to kind of get into the progression of, and this is going to be kind of morbid, we're going to talk about people getting old and then dying. So it's going to be a fun episode, but I wanted to kind of do it in order, even though we started out of order.
So we're going to be disabled first, then we're going to die?
We're just going to get old, not necessarily disabled, because sometimes just because a single parent you don't want to leave alone in another state, you put them in a care facility.
Usually with that, you're going to want to create a clone of yourself and have them nearby your parent just to watch things and not necessarily put them away somewhere, but give them an environment where they can be as independent as possible. And sometimes you get a caregiver locally. Sometimes it's in a facility where they're near, where there's a socialization and services. And sometimes it's, where the kids are.
Yeah, because I'm thinking my dad's going to turn 70 this year, and they're both in great shape. But again, all it takes is a car accident or, God forbid, a fire or something, an accident that would take them away. Not necessarily they're in bad shape. But at around 70, in my mind, it may probably even earlier, you start thinking, well, what's going to happen if he has a heart attack? Or what if they have a stroke? Or what happens if something goes wrong?
The real issue, and it's more of a global question than that, is that most people that I meet, they want to be independent. They don't want to have the courts or the governments in their lives. And they want to have their dignity and make their own decisions as long as they can. And to do this, at times when you become disabled, you get knocked in the head, you're in a car accident, Alzheimer's, you got to set up things in advance so you don't have those default rules screwing with what you want to do. And so you need to do powers of attorney to have people act for you. And you have to make sure they don't steal from you, so you can't appoint bad people. And you have to make sure that they'll do what you want. So if you want the plug pulled and not to be there with all the tubes in the hospital bed, you got to appoint somebody to do that. And then when you die, where does everything go and how do I not pay taxes? And that all requires planning. Otherwise, it gets real expensive on the back end.
And so power of attorney is probably the initial step is what it sounds like. And it sounds like you need two types. One for if you're for financial, all your stuff.
Right.
And then also what happens if, I guess, a living will type thing.
Two big categories. Money and property, that's one category, and health care.
Yeah, like a living will kind of setup.
Yeah.
So how early should you? Like I'm gonna.
Before I have to give that cheap lawyer answer of it depends and before shit happens.
Well,
you could go till you're 90 and have nothing happen, and do the power of attorney at age 90 in 3 months and it's fine, or you could be 40 going down the highway and get whacked and it's screwed. Everybody should have it once they're 18, but people don't do that and they don't think it's necessary.
So there.
I think you're invincible till you're 40, right?
I don't. Well, other people are. I rarely feel invincible, and but I would say 18 right there is. It's not very difficult to create a power of attorney. It's not very difficult. It's not like you're filling out how a will where you have to divide things.
I mean, here's the bigger problem with it. Yeah, here's the bigger problem with it. So you get all this stuff free on the internet. They can download the form or download the state form and everything. But people don't know if it's right. There's no insurance policy for you to know if what you're filling out is right or if it isn't correct. because I've had cases where they download the stuff off the internet and they do it themselves and they think it's right, and it's not, and it's incredibly expensive to go into court to deal with. And so with most people, it's, they don't want to pay the attorney $500 to do these forms. It's just filling in blanks, but people don't know what they don't know, and so that's kind of a barrier to it.
So we got the power of attorney. Hopefully you have a living will set up of some sort.
Well, here's how those work. So the power of attorney is essentially somebody stepping into your shoes and making the decisions you would have made while you are alive.
Right.
The living will is actually a backup to the healthcare or medical power of attorney, also called an advance directive. And what the living will says is, if my physician thinks I'm going to die, please don't take heroic measures to extend the dying process. And we don't know what the hell that means. Depends what hospital you're in. So it's much better to have the healthcare power of attorney on top of that, which supersedes the living will, to give the direction to the person you want, and that living will is just a backup document in case nobody shows up.
Also, it's a document for, depending on what your religious beliefs are, some people would never have a living will situation where they would just go by the law because they don't want to be unplugged at all. But it's more of a, since healthcare is the number one cause of bankruptcy in the United States, a lot of people get that living will if they're going to be comatose for the rest of their lives. They don't want their kids' inheritance wasted away.
Yeah, what you do is you appoint the trustee child as your agent under healthcare power of attorney or advance directive or whatever the hell it's called in your estate, and tell them what to do. Typically I tell my clients, I go, look, the next time the whole family's getting together at Easter or Thanksgiving or whatever it is, after the second bottle of wine for each person in attendance, have one person be the scribe and write down what mom and dad wants, and have all the kids hear what mom and dad both want at the end of life, because you need the second bottle of wine to do that clearly. And then everybody hears it, and most families are good, and they'll follow that under their authority under the healthcare power of attorney. And that's how you get that wish. So if mom wants every single medical intervention that's there, she puts the child does what she says, the child tells the doctors in the hospital what to do. And also I think we're talking about death at this point, but if they're just sick and they need a facility, I don't think people understand how much it costs to put someone in, quote unquote, put them in a home. There was a survey that came out this morning, and it said that 64% of the population have no idea what long-term care costs, and the average in the country is $6,400 per month.
That comes out to be.
It comes out to be
$72,000 a year,
it comes out to be that I can take my bank account and I can do division, and the number isn't that high when I get done.
Yeah, I can tell you that that would be they could go for the interview to see if they'd like the facility, and then we'd run out of money. Right,
but the bigger problem is that these facilities, they provide 24-hour care. It's very, very intense. And so they are actually getting value they're providing an equivalent amount of value for what they're charging. It's just so expensive to provide that.
So obviously you got to start planning ahead for just that contingency, not just...
Well, there's two options. One option is you actually plan for it and have enough money to deal with it. And the other one is what I call go out in a blaze of glory.
Well, that's what my dad said. He hopes the check to the funeral home bounces.
Yes, absolutely. Because the costs are $100,000 a year, what you have to do is either have income of $100,000 a year per spouse, or have some type of long-term care insurance or life insurance with a long-term care rider that will pay for that. And, of course, the insurance companies are going to underwrite it, and if they think they're going to have to pay, they say no. And do it within a comprehensive financial plan to see if you can do it. Otherwise, you're stuck with doing Medicaid planning and other things, and it's pretty intensive on the fees and transaction costs to do that. So planning is good, or what I like is you just have the party press the button and then you're gone.
Okay, so a big, huge, a literal big, huge blowout.
You just got to make sure you have control of the button, not somebody else.
Now, this actually kind of leads into a question from one of our listeners. When I post, as always, I post on Facebook. You should always go to the Facebook page and see what guests are coming on. And I got one when people are living the paycheck to paycheck, and they're trying to think about getting this
not only estate planning for just a couple dollars, because it can be quite costly if you have a lot of stuff and you've got a lot of siblings or a lot of people. Is there a way you can do this on a budget?
Yes and no. Here's the thing. What the estate planning does is it sets up a structure that guides you through the process. It doesn't matter if you put $2.50 through the structure or $2.5 million. It's the same amount of legal work, more or less. And so people come to me and they need an estate plan, and it's $2,000 or $3,000 or more. They're like, but I don't have anything. And I said, well, it's the same amount of work. If you had $10 million, I'd charge you the same. So some people make that choice to do it themselves. They can download stuff off the internet, Rocket Lawyer or LegalZoom. They just not know whether it's correct.
Until it's too late.
Until it's too late. Or some of these services will let you have a lawyer review it. And now this is usually a lawyer who can't get a job, who will charge cut rates and doesn't have the experience. So what it is going to a lawyer is an insurance policy that's going to be done right. And if not, there's a malpractice insurance carrier that you can get money from in case there's a screw-up. Here's an example of something that was bad. Guy comes over from Hungary, does his own will. Immigrant, no family, has this living girlfriend. Okay? He does his will, leaving this two-flat in Chicago to his girlfriend. And he did it himself. So what's the next logical step? It was done wrong. If it was done wrong, what the default rules say that if you don't have a good will, if it's not valid, and you don't have any family, the county gets it. And that's what happened because he didn't use a lawyer. Very unhappy girlfriend.
Yeah, and I think that's a lot of people, because you see these stories where guy wrote a will on a shell of a 50 caliber weapon or on a coconut or something, and it's legal, and then you realize that doesn't really work that way.
It just to unscrew these things up is incredibly expensive. In that one case that I gave you, actually, it didn't go to the county. I was able to work with it, but it was still $20,000 in legal fees because he didn't see a lawyer in the first place to make sure he did it right because he signed it on the wrong page and had the wrong witnessing.
Now,
it's simple, but he didn't know.
Now, when I was talking about these, coconut wills and these parchments of paper that you see in the movies, there's always, there's another will, and it's this, and they bring it out. And what are the actual steps to make sure that you actually have a valid will? I mean, because
each state is different. However, and your listeners should not do this by themselves because the danger is in what you don't know. But generally, the will needs to be witnessed by two people who aren't named in the will, at least. Some states require 3. And they have to know and attest, that means testify, that you are of sound mind and memory at the time that you executed the will. Then, and that's all that's really needed to make it a valid will. And it's got to be in writing. And those kind of things. It sounds real simple, but it gets screwed up all the time. And
what are the things that you see is it really a lot of siblings squabbling over property and such? Because that sounds kind of depressing to me because I know that in my family that, God forbid, my parents go, I don't believe my brother would fight for 50% or more than
95% of the families do the right thing. There's no BS. They don't fight. There might be a little bit of drama, but they're able to work it out and interact with each other like rational human beings. It's just the other 5% coming to my office.
But what I was leading to was that, I believe that even though I'm the younger son, I think they told me I'm the executor of their estate.
Okay, that means you're in charge
of
doing everything, and everybody complains to you about it not being done right.
That's fine. It's just my brother, and he can shut up. And he, like I said, I don't think he would complain. Like I said, we're pretty solid people. But I hear about executor fees, which seems like if for a family, seems like a Weasley way to skim off the top.
Well, administering an estate is a pain in the ass. You got to go to each bank where there was money and each financial institution and deal with them, and you have to secure the house and get rid of the stuff in the house and deal with the inspector and sell it and all that kind of stuff. And, you get really pissed off if you're not doing that for pay. So we have executor fees to compensate somebody from doing the work. Now, in most families, it's like, I'm going to do this because it's right, and I'm not going to take a fee. In other ones, they take a fee. Now, there are other executors. Some states say that you can charge a percentage of the value of the estate, and that's what the executor fee is. And sometimes they're just crooks, and they just bill the hell out of the estate.
And so
now, the check on that is that before an estate is closed, before the process is over, everybody has to agree to it. And if they don't, then remedial measures can be done.
Well, and then the difference between an executor and a trust, I mean, a trust is usually a third party, so to speak, or is it?
It's a little bit different. Here's the analogy. And I need to give a little bit of background for your listeners on this, just because then it'll make sense. So when somebody dies, there are 3 mechanisms to transfer an asset to a survivor. If an account has a beneficiary on it, or some accounts are called pay-on-death accounts or transfer-on-death accounts, or they just have beneficiaries like IRAs and life insurance. Whoever's name's on the form gets the money once they present a death certificate. It's particularly entertaining in a situation where there was a divorce and they didn't change the beneficiary and the old spouse is happy for 2 reasons. Not only are you not there, but the new spouse doesn't get the money.
Yeah, that's
one way.
That's called getting double screwed.
Yes. The other way is if you hold something in joint tenancy with somebody. Somebody's on a joint account or joint on the house. That's why when mom and dad die, there's rarely any probate because they had everything in joint tenancy, and the last one standing gets all the money.
Is this where civil unions might be more applicable? Is because it's kind of a contract where it's 2 people?
No, not at all. It's just a way to hold. It's a way to hold the property. It's how it's written, and then there's what I call a probate asset, which is an asset that is just in your own name. So just Craig on the title to the house, not Craig and his wife. Just Craig on the bank account with no beneficiary. The will controls the assets that are probate assets. So if an asset's in joint tenancy or there's a beneficiary on it, the will doesn't control that. And when we talk about probate, the word estate, that just means the stuff the will controls. Now, one extra thing. The analogy is a candy dish. Okay, you ever seen one of those?
Of course.
Okay, well, it's good. It's got to get good candy in it. Usually, I get the ones from my clients that are wrapped in gold because they like that better.
No, my grandmother had awful stuff that nobody liked but her.
Yeah, we don't do awful stuff. So the bowl of candy is the analogy for a trust. And a trust is just a bowl that holds your candy. Your candy are your assets. And the person who holds the bowl is the trustee. And there are instructions for when you can take candy out of the bowl and when you can take candy in the bowl. And then the bowl also has instructions that if you die, what the next person who's holding the trust, the successor trustee, can do with the assets and how they pay off debts and how they pay people. So when you do estate administration, the person who's responsible for doing things is called a fiduciary. And fiduciaries have all sorts of funny names. The fiduciary under a will is called your executor. If you don't have a will and you just have a probate estate without a will, you're called an administrator. The person who's in charge of the candy dish is called a trustee. So it's different names, but it's kind of the same position. It's just different pieces.
Well, I wanted to go back real quick because I don't want to leave the trust thing because I'm actually, the reason why I preface this is I've got several questions from listeners about trusts. But one thing you said that kind of threw me was that if my name is on the house and I'm still legally married happily to my wife, does that go into probate? Because in my mind, because
yes.
We're married, by the fact that we're married, we both legally own the property.
No, but
even
that's
if her
not
name's
the way. That's not the way the world works.
Well, that's why I'm asking, because I think a lot of people think that.
Okay, so if you buy a house, you get a piece of paper that's recorded with the county recorder of deeds that gives you the house, and it's from the seller to the buyer. And whoever the buyer is, sometimes it's the husband and wife jointly as joint tenants with rights of survivorship, or sometimes it's just one spouse. If it's just one spouse and they die, then their will controls where it goes, and the process to do that is the probate process. There are some circumstances where a title company, if you sell it later, will issue a bond instead of going through probate, but it still costs a couple $1,000s and there's some liability associated with it. So just because you're married doesn't mean you're going to get it, and just because you're married and you don't have a healthcare power of attorney doesn't mean the hospital can share your spouse's healthcare information with you if you're injured. So it's very important to have these things.
Well, that's why I wanted to bring that up, because I think a lot of people just assume a marriage certificate that is valid and they are not divorced is going to be a gateway to a lot of this stuff that they don't have to worry about. So I think that's why I wanted to bring that up. I think it's very important that people know just because you are legally married doesn't mean that you will have access to all this stuff just by showing your marriage certificate.
You're absolutely right.
And so, well, I didn't know that until you said that, so I'm very glad that you brought that up. Now, one of the questions I got was about irrevocable trust, which I have no idea which are. They said, at what point should someone set up an irrevocable trust? And then they go, if they own property or have assets over, let's say $50,000 or more. And what should they do for explain what an irrevocable trust is and why and when you should use it.
All right. A trust is either revocable or irrevocable. If a trust is revocable, that means you can change it at any time. If a trust is irrevocable, that means it can't be changed. So in a typical estate planning context, you will set up a revocable trust. It's also called a living trust because that sounds cool when you're trying to upsell that from a will, or an in revivo's trust because it's a Latin name for living and it sounds even cooler. But typically the estate planning trusts we do are revocable. There are some instances where you want an irrevocable trust, where you give up control of your own money and you put it in a trust for specific purposes. Sometimes it's to protect assets from potential creditors. Other times, if your estate is large enough to have estate tax when you die, then there is a way to set up an irrevocable trust with a life insurance policy inside of it, which will pay for the estate taxes that are due. And the life insurance trust and the asset protection trust are two types of irrevocable trusts that people use. The other thing is when a person who has a revocable trust, a normal estate planning trust, dies, on the moment they die, that trust becomes irrevocable. So to answer your listener's question, it depends on what your goals are with that. Are you afraid somebody's going to sue you? Is there something you need to do with potential creditors? Do you have an estate tax problem? So there's a whole complex litany of things you have to think about before you can do an irrevocable trust. However, if you think it's really cool to have one, so you can tell all your friends you have an irrevocable trust, I highly recommend it.
Okay. And then this person's follow-up question, which is, can trust be called anything, even something stupid? Or do they?
Yes.
So you can just name it like the Craig Price Memorial Trust.
I had a client name her trust. She named her trust the Pink Flower Trust.
Okay.
My trust, when I win the lottery, is going to have a litany of swear words in it, and I want to see what bank accepts that because I think that'd be really funny.
Oh, there you go. So you can literally name it anything you want.
Yeah, there's a line in all these trust documents that says the name of this trust is, and you fill in the blank.
Okay. So you can
sometimes
have
people make it descriptive to find out where it came from. But yeah.
So it's a fun way to mess with the lawyers and a judge to say things out loud in a court of law.
Well, if you do it that way, you'll actually attract attention, and then they'll pay attention. Which you can either get some really good quotes out of it, or they'll actually read what you did.
Well,
so there's a downside to being different. Yeah.
Well, we've just scratched the surface, and there's so much more involved in this. I mean, it's mind-boggling and it's daunting, and it can be it can be very scary because it's also you're dealing about someone yourself or someone you love dying. What is the one key thing before you go that people often forget to do that they need to do as well to make sure that it's a smooth transfer of power? I guess it's now all of a sudden it sounds like we're electing officials, but a smooth transfer so an already difficult time can be made easier.
Get your stuff in order. There's not one thing. There's a whole bunch of things you need to do. You need to make sure that if you get injured and you're still alive, that your loved ones have the ability to make decisions for you, because there's nothing that you need more psychotherapy for than showing up to the hospital and having them say, I'm sorry, because of the healthcare privacy rules, we're not going to give you any information about your mother or the medications or what's going on. Or, yes, we understand that you know that your mother didn't want all these tubes, but you don't have the documents, so we're going to put on all these tubes because we're afraid of getting sued because you didn't, your mom didn't prepare. Or sometimes, people want their estate to go without a lot of problems or expense to the children. Then you got to set up everything in a trust. Some people don't care and want to be a burden to their children. Some do, and leave their estates a mess. So it really depends on your personal preferences. There's not one thing to do other than to get educated about the process so that you can make choices that fit your desires in your life.
Well, if you want to get educated, I definitely would suggest going to you. Where can people find you?
If you go onto the firm's website, which is generationlaw.com, there is a resources page. And on the resources page, there's a free ebook called An Estate Planning Guide, which is actually written in the King's English, in active sentences, no passive language at all, no herefores, wherefores, or theretos. And it explains everything in English that people need to know to get a basic understanding of what needs to be done. Just remember that your state might be different than mine, which is Illinois, but the general principles still apply.
Now, should you have 2 bottles of wine before you read that document?
No. It's just when you're making the decisions.
Okay. So we've heard it here, folks. 2 bottles of wine, a call to or an email to Ben, go to his website, download the thing, and you will be in better shape than 95% of the people already.
Or at least you'll know how good of shape you're not in.
That's our show for this week. Once again, I want to thank Ben for coming on the show. Send your emails, questions, or guest requests to Craig@SpeakerCraigPrice.com. You can listen to the podcast in your feed on Facebook by following the show on Facebook. Our Twitter handle is @RealityCheckPod. And of course, all our episodes are available at RealityCheckPodcast.com. Have a great week.